Let's take a look at freedom of speech in public employment. Citizens do not relinquish their free speech rights when they enter government employment, but they do accept restrictions. The First Amendment, which prohibits the making of any law abridging freedom of speech, protects a citizen's right, in limited circumstances, to speak out on matters of public concern. In Pickering v. Board of Education, 1968, the leading case in this area, the Supreme Court balanced employees' speech rights against the need for workplace efficiency. The case concerned a teacher who wrote a letter to a local newspaper criticizing the school board's funding priorities and subsequently was dismissed for disloyalty and insubordination. The court found that the letter addressed a matter of public concern and had not unduly disrupted operation of the school district. Consequently, it held the board could not fire Pickering. To determine whether an employer may take adverse action, a court asks, first, whether the speech was of public concern, and second, whether the disruptive nature of the speech justifies the adverse personnel action. Trying to determine what constituted a matter of public concern proved confusing, so in 1983 the Supreme Court clarified that the speech must relate to a political, social, or other concern of the community. Confusion also arose about whether a comment made as part of a person's job was protected. In a 2006 Supreme Court case, the court ruled that an employee's expression made pursuant to official responsibilities is not protected by the First Amendment. In this case, a district attorney wrote a memo to his supervisors recommending that a case not be prosecuted because he suspected that the sheriff had lied on an affidavit used to secure a search warrant. That individual claimed that he was moved to a less desirable position, transferred to a different courthouse, and denied promotion as a result. The court denied his claim because he made the comment as part of his job. In light of the decision, a supervisor considering disciplining an employee for an expression should ask a preliminary question before applying the Pickering balancing test. Was the speech made pursuant to an employee's official responsibilities? If the answer is yes, the First Amendment is no impediment. Critics predict that this will deter employees from raising legitimate concerns, and whistleblower statutes will not overcome it. Almost all jurisdictions have enacted legislation protecting personnel from retaliatory adverse action when, in good faith, they object to agency misconduct. An employee may initiate a civil action for money and damages in court as a result.